Hello everyone, today is 15th March 2023 and this is today's Hindu newspaper's editorial article. This article is about same-sex marriage. So before we start analyzing this article, I would like to request all of you who are watching my videos, if you like my video, then please subscribe my channel and share my videos and hit the like button. It will motivate me to create more such videos in coming days. So on that note, let's start reading this article. The Supreme Court's decision to refer to a constitution bench the issue of granting legal recognition to same-sex marriages can be seen as an important step towards ensuring gender equality, despite apprehension that it is encroaching on the legislative domain. Okay, so the very first term that we have to notice is this one, constitution bench. Okay, so what is constitution bench? So this is a kind of bench of Supreme Court which is formed when the matter is very crucial regarding any substantial question of law. Okay, when the judges have to decide on a very substantial question of law, or they have to interpret any question or any issue regarding the constitution itself, then this kind of benches are formed. Okay, so the constitution bench is for a very crucial or very substantial question of law. For that kind of issues, these constitution benches are formed. For a constitution bench, the minimum strength of judges should be 5. Minimum strength of judge should be 5. I think I should write it down here. So in a constitution bench, strength of judges should be 5 or more. Okay, this is the first point, that in constitution bench strength of judge should be 5 or more. Okay, what kind of other benches are there? There are division benches. So a division bench is 2 or 3 judges bench. Okay, that is called a division bench. And only Chief Justice of India, CJI, he is authorized to form and refer cases to constitutional bench. Okay, as per constitution, only Chief Justice of India is authorized to form and refer cases to constitutional bench. And you can write it down because these informations may help you in further course. Okay, and first constitution bench was formed in 1950. First constitution bench was formed in 1950 and it was A.K. Gopalan versus State of Madras case. Okay, it was A.K. Gopalan versus State of Madras case, and till now largest constitution bench has been, you know, this case. This is a most famous case in constitutional cases, Keshavananda Bharati versus State of Kerala. Total 13 judges were there in this case. Okay, so now you have all this data regarding constitution bench, that strength of the judge in constitution bench should be 5 or more. Other than constitution bench, there is division bench in which 2 or 3 judges sit in that bench. Only Chief Justice of India is authorized to form a constitution bench and he can only refer cases to that bench. And then first constitution bench was formed in 1950, A.K. Gopalan versus State of Madras case. And till today the largest constitution bench is Keshavananda. Okay, wait, Keshava Nanda Bharati versus State of Kerala case. Okay, and in this case the basic structure of constitution, that doctrine was arrived. Okay, so total 13 judges were there in this bench. So let's continue reading that the Supreme Court's decision to refer to a constitution bench the issue of granting legal recognition to same-sex marriages can be seen as an important step towards ensuring gender equality despite apprehension that it is encroaching on the legislative domain. So Supreme Court is deciding that they are going to form a constitution bench. They are going to form a constitution bench. For what reason? They are going to form it so that legal recognition to same-sex marriages can be decided whether any such legal recognition is to be given to same-sex marriages. So that can be decided. For that reason, this Supreme Court's constitution bench will be formed. Okay, this is a very crucial issue. There are so many petitions right now lying in Supreme Court and high courts also regarding these same-sex marriages. So Supreme Court has now acted upon all these petitions, and what they are doing, they are trying to decide whether there will be same-sex marriages will be legalized or not. Okay, so this is an important step towards ensuring gender equality. Editor is saying that this is an important step towards ensuring gender equality because same-sex marriages means a marriage between a male and a male or a female and a female. Okay, so despite apprehension that it is encroaching on the legislative domain, what is the apprehension? Like, who is contending this Supreme Court's decision? Who is contending it? It is the Union government, that is Government of India. So Government of India is saying that this law, if there is any law to be formed, if there is any law or any bill to be passed regarding same-sex marriage, then such a law should be passed or should be brought by the Parliament only, or the legislative part of our democracy only. Okay, Supreme Court is the judiciary part. In the pillars of democracy, Supreme Court or the courts are the judiciary part, and there is this legislative part. So what Government of India's argument is, if any such law is to be passed, then that law should be brought by the legislative portion, that is our Parliament. It should be brought by our Parliament, or if there is any requirement of such law, it should be passed in the Parliament. It is not the domain of the judiciary to bring such a law. That is the argument of Government of India. The Government of India is saying that Supreme Court or the judiciary is encroaching on the field of the legislation. Okay. Next, petitioners before the court view the idea of giving of legal status for marriages between people belonging to the same sex as a natural consequence of the 2018 judgment decriminalizing homosexuality. Okay, so what is this judgment? We again will write it down. What is this judgment? I am erasing this writings. Okay, so the 2018 judgment, in that judgment, Supreme Court decriminalized homosexual relationship or consensual homosexual relationship. Okay, so before 2018, sexual relationship between two persons of same gender means if the two persons both are male or both are female, then sexual relationship between such the two persons of same gender was a criminal offense. Before 2018, such sexual relationship was criminal offense, and it used to come under section 377 of IPC. Okay, I am again writing this data down. It was under section 377 of Indian Penal Code. Okay, IPC. So what happened in 2018? In 2018, Supreme Court gave a landmark judgment in which Supreme Court decriminalized same-sex relationship. If it is a consensual, that means both parties have consent to establish sexual relationship between them, then they decriminalized it. They gave the judgment that it should not be or it will not be considered as a criminal offense anymore. Okay, so the 2018 case in which this landmark judgment was given that homosexual relationship will not be a criminal activity anymore. So that case was, I'm writing down the name of the case. It was Mr. Navtej Singh Johar versus Johar and others versus Union of India. Okay, this was the case. So who is Mr. Navtej Singh Johar? Mr. Navtej Singh Johar, he is a famous Bharatnatyam male Bharatnatyam dancer. Okay, he is a famous male Bharatnatyam dancer, and he is first Sikh. Sorry, he is first Sikh to perform this art form. Okay, he is the first Sikh person to perform this art form, and also he is winner of Sangeet and Natak Academy Award. Okay, he is the winner of Sangeet and Natak Academy Award. He is also a prominent LGBTQ activist. So now you know about Mr. Navtej Singh Johar. So in his case, this landmark judgment was provided. The government, however, contends that there is no need to depart from the heteronormative understanding of marriage. So our government, that is Union government, Government of India, government's argument is that there is no such need to depart from, that means there is no such need to take a separate action regarding this same-sex marriage, because there is no need to come out from the heteronormative understanding of marriage. So government is saying that marriage itself means this has to be an union between two persons who has to be of different genders. It can be a male and female only. Okay, so this is the understood definition of a marriage. So government of India is saying that there is no such need or no such requirement to depart from that definition of marriage, or to depart from that usual definition of marriage, and therefore there is no need to uh, enact a new law regarding same-sex marriage. And even if there ought to be such a change, it must come from the legislature. So government is saying that if such a change or if such a law is to be enacted, then it should be enacted by the legislature. Okay, it should be enacted by the parliament. There is no provision or there is no authorization to the judiciary to encroach in their matter regarding this. Okay, now next, the question before the court is whether it should interpret provisions of marriage laws in India, especially the Special Marriage Act 1954, as permitting marital unions between same-sex couples. Okay, so you know that there is this Special Marriage Act 1954, which allows two persons from different religion or different caste to get married. Okay, because the Hindu Marriage Act, it only allows marriage union between two persons who both of whom are Hindu. Okay, and the Muslim Marriage Act, that also allows only when if those both of the persons who are marrying, they are Muslim. Okay, so if some interfaith marriage is taking place, then to conduct such a marriage in their respective religious marriage law, one person has to convert to other person's religion. Okay, but this special marriage act allows both of the person to keep their faith, keep their original faith. They do not need to convert into each other's religion. Okay, and they can get married by. So this special marriage act, this act allows two persons from different religion or different caste to get married. Okay, so the question before Supreme Court is that they are now trying to interpret provisions that whether the same-sex marriage can be put under this Special Marriage Act 1954. The act allows the solemnization of a marriage between any two persons and is used by those who are unable to register their marriages under their respective personal laws. Just as I already explained, that this Special Marriage Act, this act allows a marriage or a union between two persons who are from different interfaith, who are from different religion, or who are from different caste, and they cannot marry under their respective personal laws. Okay. So the Union government has argued that the decriminalization of consensual relations between adults of the same sex has removed the stigma attached to homosexuality, but has not conferred the right of marriage. Okay, so the Supreme Court's argument is that in the 2018 judgment, when the same sexual relationship was decriminalized, then it helped that society, it helped the society to come out of the stigma that it had for a long back. Okay, there was a stigma in the society that same sexual relationship should not be taking place, it is something unnatural. So this stigma has now been faded because of the Supreme Court judgment in 2018. So the Union government's argument is that it is the society has already started coming out from the stigma, so there is no such need now to confer right of the marriage. Okay, and the government is also saying that the judgment in 2018, it does not cover or it does not confer any right of marriage. Okay, it was only about sexual relationship, but it does not cover the marriage between two persons of same sex, and that this state is entitled to limit its recognition to marriages involving heterosexual couples. So government of India is saying that only the state, it means only the government, the union government has the right, only the union government has the authorization, that means the parliament has the authorization to if any recognition is required in this regard. Okay, so it comes in the scopes of the parliament only, it is not a scope of the Supreme Court or the judiciary. There is no discrimination, it claims, in keeping same-sex couples out of the definition of marriage. So here, this is the argument of the government of India, that they are saying if we keep same-sex marriage or same-sex couples from the ambit of marriage, from the definition of marriage, then this is not a discrimination. There is no discrimination is happening over there. Okay, because the very word marriage, the very definition of marriage, because the very definition of marriage means it has to be between two persons from different genders only. Okay, it cannot be compared with sexual relationship. Marriage is different, sexual relationship is different. Same sex people can have sexual relationship, but it cannot be the same with marriage. That is the argument of Union government or government of India. Okay, so what is the argument of the editor? In terms of the equality norm, the central question is not very complicated. It can be recognized that no civil right available to married heterosexual couples ought to be denied to those who belong to the same gender. So here the editor is arguing that the rights that one heterosexual couple enjoys, those rights are not available to same sexual couple. Okay, so this is where the importance of marriage comes, because when two heterosexual people marry, because when two heterosexual persons marry, then each of them enjoys certain rights they can only get after the marriage is then when two heterosexual persons marry, then there are certain rights they enjoy. Okay, but these rights are not available to same-sex couples. So what are those rights? So I am writing down all those rights. Okay, so these rights are employment benefits. Okay, These rights, so those rights can be employment benefits, it can be health insurance, it can be family leave, bereavement leave, okay, it can be family benefits, okay. Then there are very financial rights, several financial rights like joint locker facility, joint fixed deposit, joint bank account. Those kind of rights are there. Then there is government benefits. Then there is many tax and estate planning related benefits that the married people get. There is medical and death benefits, pension, all those things. All these things, heterosexual married couple they enjoy, but these rights are not available to same-sex couples. These basic rights which the heterosexual married couples are enjoying, those same rights cannot be denied to same-sex unmarried couples. So that's why the importance of marriage comes. Okay. Next, the incidental consequences on issues of property and succession may not pose insurmountable difficulties. The center's other argument invoking religious norms and cultural values against recognizing same-sex marriages is weak and inadequate. So the argument that government of India is giving is that it is marriage is a religious institution. Marriage is something which goes back thousands of years. This is such kind of a religious practice. It has a long cultural value, a very ancient cultural value. It is futile to argue that it will undermine faith or rock societal values. So the editor is saying that the argument the central government is giving, that argument is completely pointless. It is baseless argument, and that same-sex marriage, legalizing same-sex marriage, may hurt anyone's religious sentiment, or it may degrade our social and moral value. Those arguments central government is giving, these arguments are pointless and baseless. Okay. The mere fact that many people consider marriage to be a sacrament of a holy union is not enough to deny equal status to the union of people of the same sex, or to undermine its essential character as a social and economic contract. So what is marriage? Marriage is a social and economic contract. Okay. So marriage has a very important role to play in a person's life. Okay. When two people, they are loving each other, they are residing with each other, then this union, this social and economic union should happen, because this union this union will help them to lead a better life in our society. Okay. Just because some people still stigmatize same-sex marriage or same-sex relationship, it does not mean that those people who love each other, who are from the same gender, same sex, they want to live with each other for the rest of their lives, they should be victimized. Okay. Because ultimately it is these same-sex couples, they are going to suffer for it. Okay. The society, the other people, they are not going to suffer for it. They will just continue stigmatizing this, but their life will not be affected. Okay. Whose life will be affected? It is these people, the same-sex couples. Okay. Whether the remedy ought to take the form of recognition of same-sex marriages, and if so, whether it should be through judicial intervention or legislative action, is the question. So now what is to be seen? Everyone is waiting for what is going to happen in the next few days or in the near future, that whether the same-sex marriage will be legalized or not, whether it will get recognition or not, and if it get recognition, then how it will be done, whether it will be a judicial intervention, like it will be decided by the court. Okay. Or there will be any legislative action, that parliament will come forward and they will enact some law, or they will bring forward some bill like that. Okay. So from which intervention, whether it is a judicial or whether it is a legislative intervention, that has to be seen. Okay. That the legislature should be involved in bringing about far-reaching changes that may impact the personal laws of all religions is indeed an acceptable proposition. So editor is saying that the legislators, that our parliament, our leaders, our political leaders, okay, they should come forward proactively. They have to implement far-reaching changes that may impact the personal laws. Like all the religions have some personal laws that are not fit for 21st century. These laws have been there for centuries, okay, but it doesn't mean that each and every law which we have followed for last couple of hundred of years, okay, so these laws should be fit in our coming future also. It does not mean that. So these laws needs to be again checked. These laws, if any amendment is needed, then such amendments should be proactively brought forward by our legislature, okay. A responsive government that wants to treat this as a matter of policy and not cede space to the courts would act on its own to consider the right of any two people, regardless of gender, to marry or found a family. So if a government is a responsive government, if a government is proactive government, then that government will start acting even before the courts intervene. Okay, if our government was proactive enough to bring about such changes, to enact such laws for the right of the same-sex couples, then the judiciary didn't even have to intervene. Okay, why the judiciary is intervening in this? Because there was no initiative from the legislature's end. Okay, because there was no act, there was no bill brought forward from our legislature side. That's why judiciary is intervening in this. So that is the data saying that a responsive government should have proactively brought forward such kind of laws without waiting for the judiciary. Okay, legislative inaction on burning social issues will legitimize and invite judicial intervention. So if there is any inaction from the legislative side, if our leaders they are not ready to bring forward changes which the society needs, okay, then obviously the judiciary come forward and they will legitimize, and such kind of judicial intervention will be welcomed by the society. Okay, again, if you like my videos, then please do subscribe my channel, hit the like button, share my videos, and write me in comment what kind of content you'd like me to create. Okay, thank you all.